welcome to the Exit Readiness Podcast. My name is Pat Ennis of Ennis Legacy Partners, and I'm here with my co-host, Walter Dial, CPA, who is a partner at Gelman, Rosenberg & Friedman, CPAs, located in Bethesda, Maryland. In his book, How to Run Your Business So You Can Leave It in Style, John Brown says the following. The Business Continuity Agreement, or BuySell Agreement, is the single most important document that you, as the owner of a closely held business, will sign. Walter, a business owner may or may not agree with Mr. Brown's statement that it's the most important document they will sign, but I know you and I would agree that it is critical and that it's easy to get wrong. What have you seen in your practice as consequences to either not having a buy-sell in place or one that's poorly written?
Well, Pat, I think I've seen a few situations where either a buy-sell wasn't in place or was poorly written. As far as the poorly written situation, the issues I've seen most common is where the valuation of the business is left in very murky words. So you may have, a spouse of a deceased partner who's convinced the business is worth a lot of money because that's what her spouse has been telling her. But the buy-sell agreement may have a totally different definition of value, and she was blindsided by that. And the other situation, unfortunately, we see from time to time is just where a buy-sell just didn't exist. And you have, one of the owners dies, the spouse of the owner goes to the living owner and says, okay, I'd like to get my cash out of this business. And there's been no provision to provide any cash to the widow. So I think this is a very important area. So I was really excited when you said you're bringing Larry in to discuss this because he's an expert in the matter, and I think it's very important for our business owners to hear what he has to say today.
Yeah, so that's right. Our guest is attorney Larry Bell, and he's going to help listeners better understand why this document needs special attention. Hey, Larry, how you doing? Happy holidays.
Pat, thank you for inviting me. Walter, nice seeing you again. I hope everyone is well.
Larry, let's begin with you describing your background and practice, which is extensive.
Well, thank you. I was an attorney in private practice for 25 years. I received my master's degree in taxation and taught in the fields of estate planning, business planning, and tax-related matters. I went in-house with a client and worked in the valuation and actuarial fields for 5 years. And for the last 15 years, I've used a multidisciplinary approach to work with clients in the fields of private companies, public companies, nonprofit organizations, both nationally and internationally.
As you know, Larry, Walter and I both help business owners plan their exits from the business. And we would agree that one of the legal documents that is absolutely essential to get right is the Business Continuity Agreement or the Buy-Sell Agreement. Our first question for you today, Larry, is explain the purpose of a buy-sell agreement, why it's needed, why it's necessary.
A buy-sell agreement is probably one of the most practical planning tools from a business, tax, and estate planning orientation. What it permits the parties to do is to plan for those unexpected eventualities. So it gives you a roadmap, and I think we all agree people drive better with a roadmap.
So what are the advantages if I'm a business owner and I have a buy-sell agreement? What are advantages to me as a seller, and then I want you to tell me the advantages of a buyer to a buyer.
As a seller, it gives a higher degree of certainty as to what would happen during your life or upon a disability or upon death. As a buyer, it gives a planning opportunity so that you can use funding to the extent available to fund now for the eventuality in the future, and depending upon the facts as they occur, it may be the most economically efficient way to build your base with an exit strategy if it's not to your surviving partner, to a third party, or to employees.
Okay, follow up. You mentioned life and death situations for the seller. What about death and disability situations for the seller? What about if they live and they have a partner or partners? What about life transition situations?
Life transition situations permit the owner or owners of the business to agree with how the pie is going to be split it gives the opportunity to have continuity, whether that is within the company or in selling to an unrelated third party. It also is a showing upon audit and upon other review by regulatory agencies that you have your house in order.
So, Larry, what are some of the major issues to be considered when someone's drafting a buy-sell agreement? I imagine you need to be concerned about what events are going to trigger the agreement to come to life, and of course there's tax considerations. Talk about those a little bit and any other considerations.
Walter, that's very important, those issues. And just as a side point, when you generally hear about buy-sell agreements, you look upon the death of a participant.
Right.
And then you look sometimes as to the disability. Well, it's interesting for those owners out there that between now and when you reach 65, you've got a 1 in 4 chance of being disabled and only a 1 in 7 chance of dying. So it's statistically greater likelihood that you're going to become disabled before you retire than you're going to die. But I would share with you that the vast majority of the buy-sell agreements out there will have the death buyout, but they very likely do not have a funded disability or, and you raised this point before, formulaic. Whether your buyouts for death, disability, or life, whether it's a formula or whether it's a set dollar amount, they must be reviewed, and generally speaking, every 3 to 5 years.
Right. And what do you see as the major tax considerations?
The major tax consideration, and as we're talking today, we're right on the cusp of having what will probably be a new tax law. And so historically, we had 3 different types of buy-sell arrangements. You would have a cross-purchase, you would have an entity purchase, and you could have a trustee cross-purchase. While a corporate entity purchase was a neat way of doing things, it was simple, just one policy per person, it created a different issue, and that was alternate minimum tax.
Right.
So while there is income tax considerations, you would then also look at the alternate minimum tax that may or may not be changing. With a cross-purchase, you did not have the entity purchase arrangement, so you could avoid that level of taxation.
Right. So it sounds like if the tax law does go through and they're calling for the repeal of the corporate alternative minimum tax, maybe the first situation you described, which is simpler, could come back into play.
Clearly, everyone wants things to be simpler.
Yeah.
One of my favorite tools, however, is the trustee cross-purchase agreement. Now, let me explain. A trustee cross-purchase agreement has all of the benefits of a cross-purchase agreement, that it's one policy for each owner, as opposed to with a cross-purchase agreement, if you had 3 partners, you would have 3 times 2 times 1, you'd have 7 different policies. So that was a reason not to use cross-purchase agreements. And then to make matters more complicated, a trustee cross-purchase isn't a trust, but it's a partnership agreement in which you have one policy per participant. And so by using the trustee cross-purchase agreement, we were able to avoid the alternate minimum tax and not have a multitude of policies. But you're absolutely right. With the dropping of the corporate alternate minimum tax, it reduces that tax. It creates a different problem, and that is that with the entity purchase, the life insurance policy that was funded during life, the operating company did not get an income tax deduction for that, and it was an asset of the company. So that many times, particularly with entities that had multiple owners, such as physicians, architects, accountants, where you would have the policies purchased and owned by the operating entity, when a departing shareholder left, it was creating an issue, because if you had a permanent policy, then that individual that was using it to fund their death buyout then would have to buy the policy from the operating company, and not many individuals that were in those plans, one, even realized it, or two, wanted to have to buy something that they felt they were taxed on as they went along.
Right.
What about retained earnings with the stock redemption or the corporate redemption buyout that you mentioned? Isn't retained earnings an issue as well?
That's a very good point, and I forgot. You're right. Retained earnings with a C corp would then create. That's another issue. And so, if we're all about simplification, let's figure out a way. And I don't want to concentrate too much on a death situation because, as I'm saying, most people are going to live through to reach retirement, and they're going to be looking at a buyout. But retained earnings is always an issue.
So what do you see as other common mistakes when people are drafting these agreements?
A very common mistake is that what the agreement says, let's say, for example, it was a cross-purchase agreement, and yet the policies are issued to the operating company and the payments are paid by the operating company. So you want to make sure your funding approach is consistent with the document as it is drafted. The next most popular mistake is what you referenced earlier, and that is it's not like you sign the agreement, put it in the drawer, and forget about it. You have to look at that. You should look at the agreement every few years or with any business or life change, and the formula, if it was a set dollar amount, that number may well be surpassed by the real growth in the company, so that then it's great for the surviving shareholders, but the spouse of the deceased shareholder may not like the idea that they're getting pennies on the dollar of what the real business is. Also, in order to have a dollar amount that is set for purposes of the IRS reviewing it and accepting it for estate tax purposes, that figure has to be not only as set forth under the agreement upon death, but it also has to be a figure amongst the parties that is enforceable during life. So that to have a push down on the value of the business and then for estate planning savings, but then having it so under a departure somebody could get stuck by the other ones, you're not going to have somebody being happy. And so it's having the document in line with the funding and also making sure that that figure is always consistent with what you'd be prepared to sell a willing buyer paying from a willing seller.
Yeah, there's some key. Are there areas that aren't addressed often that should be that you see?
I ran into a situation just a week ago. The good news is I wasn't the drafter. It was a group of 4 owners, and they had an insurance professional, did a great job, went out and got the life insurance. And they got a very well thought of attorney to review it and got the accountant to agree as to what the value was. Sounds great. They took it another step because we were talking about a premium in the millions of dollars for the 4 participants, and they did a premium finance so that while the payment was going to the insurance company, they were using leverage dollars to do it. All makes sense. It's done. Made the first payment, made the second payment, and then after the second payment and before the third, one of the principals committed suicide. Now, what the problems occur here is, one, there's a 2-year look back so that the insurance company may not necessarily pay off on the death benefit used to buy out the interest of the deceased shareholder. That's bad 1.
Right.
Bad 2 is the bank lent the money based upon getting paid off sometime in the future or upon the death. There's no blossoming of a death benefit to pay back on the premiums that are owed. The good news is everybody's talking, they're working through it and figuring out what's going to happen. And the deceased...
So how could that have been avoided, though, in the document? Should they have mentioned something about suicide within a 2-year period?
Candidly, I had never seen that occur before. However, I euphemistically indicated to the insurance professional that you should notify the attorney so that in the future the documents read that way. It could be very clearly it could be set forth that upon insurance not being available, and by the suicide, then the insurance would not be available. There could then be a less optimum arrangement to take care of the family of the deceased shareholder without that family of the deceased shareholder becoming an owner.
And it would be particularly tricky in the case where the premiums are being financed.
Yes.
Mm-hmm. Okay, so I think you answered this a second ago, but, is it good enough for an owner to have a buy-sell agreement drafted and then leave it on the shelf, never to review it again until it's needed? Or how often should a document be reviewed?
Many times that is exactly what happens, in which case it's a backup while having that document that gets moldy in the drawer. If you use not a flat dollar amount but some formula based upon some revenue enhancer, that's a way for a backup. But still, in the same way as the client's will should be reviewed every few years, or with any major tax law change, or in the same way as when there are new children born or a divorce with a will, you go and you look at your document. That should also happen with the business. So it's good. It is a living document. You want to make sure it's meeting your needs. So it's something that while we don't look at it every day, we don't look at it every year, it's something you should be mindful of.
Yeah, that's a really good point, Larry. Let me ask you a question. A certain percentage of our listeners, they don't have partners or other shareholders. It's just them. They're sole owners of their business. How does this discussion of a buy-sell apply to them?
Where there is no immediate successor, then one of the things that can be done, depending upon the relationship between the participants, would be that the owner of the company, and this would be true whether it's an S Corp, a C Corp, sole proprietorship, or what, they could bonus out to a partnership or a trust composed of the employees of the company. And then that premium stream could be used to fund for a death benefit made available to those participants in the partnership or the trust, so that upon the premature passing of the owner, then the life insurance blossoms and that money is used to buy out a state's interest, and then those surviving or the owners of the business could then use that cushion, that money, to buy out and or to keep the business going until, as a going concern value, that business got sold.
That's really interesting. That's really smart.
Okay, so Larry, as we wrap up, are there any final comments or recommendations, suggestions that you would make to listeners, as particularly in light of what you brought up earlier, the tax reform that's coming?
It's very important to deal with people, advisors that know what they're doing. Doctors were very wise much earlier than attorneys were. They developed specialties and they became more siloed. They then affiliated with other groups, but they kept their specialization. Lawyers are doing that more and more now, and then organizations such as yours that are specializing in the legacy planning, the exit strategies. The owner of a business should avail themselves of that knowledge base that's out there, because it's constantly changing, and it's time well spent.
Fantastic. Okay, share with the listeners how they can reach you if they need help either reviewing or drafting a new document.
Well, thank you. I work in the Washington metropolitan area, and I'm most easily reached on my email address, which is larrybell@theuniquesolution.com, or at 240-604-6945, and I will return your call.
Thank you. Okay, Walter, what do you think listeners should keep in mind as a result of this interview?
Well, I think this interview is the classic example of what I see as the benefit of these podcasts for our listeners, because it's just a really timely, we're at the end of the year, it's a very timely reminder to pull your buy-sell off the shelf and take a look at it. If you don't have one, contact Larry and get one. It's one of these things that doesn't cost a ton of money, doesn't take a whole lot of time, but the return is incredible.
Yeah, it can save a lot of money, a lot of hardship. Yeah, that's right. Well, thank you, Larry. Listeners, our goals for this podcast are simple. We want to provide information that will help you, the business owner, build transferable value or value that someone else is going to want to buy or own. We want to help you plan your exit so that you exit on your own terms and conditions, and also encourage you to begin planning now. If you wait until you're ready to exit to begin planning, you won't be ready, and neither will your business. If you found this information today to be helpful, please consider sharing the podcast on social media. Check out our services at nslp.com and Walter and his firm at grfcpa.com. Special thanks to Charlie Burney and the Podcast Village for hosting us. Thank you, folks, for tuning in. Until next time on the Exit Readiness Podcast, this is Pat Ennis and Walter Dial signing off.